Hello, Bradley Pierce here. I've been a Texas lawyer for the last 14 years. I'm the executive director of Abolish, Abortion Texas, and among other things, I draft and analyze legislation for a living. So today, let's analyze the pro-life bill together. Today I'm going to be talking about Senate Bill 391 by Senator Angela Paxton. It's soon to be Senate Bill 9 when it's refiled because it's a priority of the Lieutenant Governor Dan Patrick. In the House, it's currently designated as House Bill 1280 by State Representative Giovanni Capriglione. So my analysis is about the bill itself and not about those who are carrying the bill. We're going to talk about the text of the bill. So let's go ahead and get into the bill. All right. So you'll see over here, this says, this act may be cited as the Human Life Protection Act of 2021. That's section 1 of the bill. So far, so good. We're all about protecting human lives. All right, the next section is we are adding Chapter 170A to the Health and Safety Code, which is right before there's a number of abortion-related chapters there together, so they're adding a new one there about abortion. Now, one interesting thing about this that I just see straight off is that we're dealing in the Health and Safety Code rather than the Homicide Code. Why are we dealing in the Homicide Code? Right? If you kill someone who's born, it's going to be under the Homicide Code. But if you kill someone who's unborn, looks like they're trying to make that fall under the Health and Safety Code. So not necessarily a big deal yet, but it's an indicator that this bill is probably not going to be treating the death of an unborn child the same as the death of a born person. It's probably not going to be providing equal protection. So just something to watch out for. All right, let's keep going. All right, we see here that they're defining abortion, and it says it has the same meaning assigned by Section 245.002. I have that pulled up. Let's take a look at that. That says in this chapter, and this is saying for this bill as well, abortion means the act of using or prescribing an instrument, a drug, a medicine, or any other substance, device, or means with the intent to cause the death of an unborn child of a woman known to be pregnant. The term does not include birth control devices or oral contraceptives. An act is not an abortion if the act is done with the intent to save the life or preserve the health of an unborn child, remove a dead unborn child whose death was caused by spontaneous abortion, or remove an ectopic pregnancy. So that's the definition there. There's numerous statutes across the state of Texas that refers to that definition, and that's a very common definition, not just in Texas, but across the country for abortion. It was very common for it to be something along those lines. So then we have definition of fertilization, definition of pregnant, reasonable medical judgment, unborn child, which means an individual living member of the Homo sapiens species from fertilization till birth, including the entire embryonic and fetal stages of development. Okay, really, so far, no big issues so far. All right, so let's keep going, because now we're going to get into the substance of the bill, or what the bill actually does. So then it creates this new section 170A.002, prohibited abortion and then exceptions. It says a person may not knowingly perform, induce, or attempt an abortion. Period. That's the end of it. Okay? Great. So far, so good. The prohibition under subsection A does not apply if the person performing, inducing, or attempting the abortion is a licensed physician who, in the exercise of reasonable medical judgment, the pregnant female on whom the abortion is performed, induced, or attempted has a life-threatening physical condition aggravated by, caused by, or arising from a pregnancy that places the female at risk of death or poses a serious risk of substantial impairment of a major bodily function unless the abortion is performed or induced. So let's stop there for a minute. So this is what's often called a life of the mother exception. Everybody understands that there are certain situations where there, especially like an ectopic pregnancy, where a procedure may be done where there's not an intent to take the life of the child, but everyone knows that it's going to happen when you remove the part of the fallopian tube that contains the child, which is growing and which could burst and which could put the mother's life at risk if left undealt with. So that's not an intentional killing, and it's not, it shouldn't be a crime for doctors to triage patients in those situations, as long as they're trying to save the life of both, as long as they're doing everything that they can to save the life of both. In some ways, this prohibition this exception is unnecessary, because scrolling back up to the definition of abortion, which is from 245.002, this says abortion means the act of using or prescribing an instrument with the intent to cause the death of an unborn child. Okay, well, removing an ectopic fallopian tube that contains an unborn child, you're not intending to cause the death of an unborn child. You know that is going to happen, but you're not intending. So this exception is not really necessary, but people often will put it in because it just makes people feel like they're dealing with that sort of situation, even though from a legal perspective it's not really necessary, since there is no intent to cause the death of an unborn child when removing an ectopic pregnancy. However, it does, there is some vagueness here in this bill, as far as they're saying any kind of condition that places the female at risk of death. I mean, that's very vague language. It's not defined anywhere else. I've already looked. And, are we talking 1% risk? Are we talking 99% risk? Are we talking 0.0001% risk? What kind of risk are we talking about? At least with the, risk of substantial impairment of a major bodily function, it says a serious risk, right? So it has to be a serious risk. Whereas the risk of death, it's not quantified at all. It's not modified at all. So, it's kind of a big loophole potentially there that exists. So let's keep on going. So anyways, let's continuing with that exception there. And this is just another way of stating it here. And then it says that kind of medical treatment in emergency that results in the accidental or unintentional injury or death of the unborn child does not constitute a violation of this section. Again, that's really redundant, since we've already defined abortion to be the intentional causing of death. So saying, an unintentional, death does not constitute a violation of the section. Well, yeah, I mean, that's why we defined it to say intentional is abortion. But anyways, let's keep on going. The next section says this chapter, which just contained the ban that we just saw, may not be construed to authorize the imposition of a criminal, civil, or administrative liability or penalties on a pregnant female on whom an abortion is performed, induced, or attempted. So this is really creating immunity for the mother who seeks an abortion. Now, we're no longer talking about an abortion in a medical emergency. Now we're talking about all abortions. This says that this chapter may not be construed to make her liable, civilly, criminally, or any kind of administrative liability or penalty as well. Cannot be imposed on a pregnant female who gets an abortion. So this is really just saying that mothers are immune for abortions, for the abortions that they seek. And really what this does is it really codifies a right to an unassisted abortion for the mother, right? This bill is outlawing abortion performed by abortion doctors, by abolitionists, but not for the mother. And in fact, it's saying that mothers are basically have a right to cause the death of their own unborn child as long as they do it unassisted. That's what this is codifying. And really, this is a denial of equal protection. So the 14th Amendment of the U.S. Constitution says that no state shall deny to any person within their jurisdiction the equal protection of the laws. Well, that means that if we believe that a fetus is a person, right, a baby from the moment of fertilization is a person, whether they've been born yet or not, that then the laws that apply to born people should apply equally to people before they're born. Well, once you're born, no one has a license to kill you, right? No one can kill you if you're innocent, right? No one can kill an innocent person with impunity. No one can do that and get away with it. No one has a license to do that, except with the issue of abortion. And that would be perpetuated under this bill, that a mother would have a license to kill her own child, and that would be codified, and that would be protected by law, that she would have the right to do that as long as she does it unassisted. Again, this is a denying of equal protection, which really is how we got Roe versus Wade in the first place. And it's why I believe it's one of the big reasons, if not the biggest reason, why we've been unable to get rid of Roe versus Wade for the last 48 years across this country. So This section of the bill is a real problem, but it's not unusual. You see this in almost every single pro-life bill, that there's whether it's necessary or not, or whether it applies or not, there is an exception that's created for the mothers that excludes them from any form of prosecution and excludes them from the justice system at all. And when I talk about that, we're not talking about equal outcomes, that mothers should automatically get the exact same punishment as the abortionist who's done 10,000 abortions. But what we're saying is that what equal protection means is not equal outcome. It means that the law applies equally to protect both people before they're born and after they're born, and that people who commit this kind of conduct, abortions, or hire someone to commit that they are equally subject to the same justice system that applies to everybody else. Again, it's not saying what the justice system should decide, but it's saying that every case, instead of saying that all mothers should be automatically immune from prosecution no matter what the situation, instead of saying that, we're saying no, our justice system should consider each case on a case-by-case basis. But that's not what this bill does. This bill just says all pregnant females are automatically exempt from the ban created by this bill on abortion. All right, let's move on. Let's see here. The next section makes it a criminal offense. So the person who violates 170A.002 commits an offense. And then it says that it's an offense of the felony of the second degree, except it's a felony of the first degree if an unborn child dies. So if you attempt an abortion, it's a felony of the second degree. But if it's actually a quote-unquote successful abortion and the child dies as a result of the offense, it's a felony of the first degree. Now, that's already lowering the penalty. That's a pretty high penalty, but it's actually a lower penalty than if we're talking about homicide of a born child. So, again, we're not providing equal protection. Now, not only is the mother immune, but we now have a lower penalty for killing an unborn child as opposed to killing a born child, which is called a capital felony. So, again, we're seeing the denial of equal protection by this bill, which, as if you go back and look at history, that's how we got Roe v. Wade in the first place. The law in Texas before Roe v. Wade did the exact same thing. Mothers were immune from prosecution. There was a lower penalty. And the Supreme Court in Roe v. Wade actually used those two things as a reason to decide in favor of Roe and create, or purport to create, the so-called right to an abortion, because Texas was being inconsistent. And the court even pointed out, if the fetus is a person, why is the mother immune? If the fetus is a person, why are the penalties different? That's actually in the Roe v. Wade majority opinion. You can go see. So we're just perpetuating that, and this is not the way to get rid of Roe v. Wade. Is to perpetuate what led to Roe v. Wade in the first place by denying equal protection to people who are not yet born. If a fetus is a person, then they are entitled to the same laws that protect all other persons. And as long as we deny them that, then we're not really acting like they're persons. All right, let's keep going though. Civil penalty. So there's a $100,000 fine for someone who commits an abortion, and that can be brought by the Attorney General. It doesn't say anything about a private cause of action, but I'll talk more about that in the next section. Looking at the next section, civil remedies unaffected. The fact that conduct is subject to a civil or criminal penalty under this chapter does not abolish or impair any remedy for the conduct that is available in the civil suit. So this says that we're not creating a private cause of action. In other words, you can't sue the abortion doctor if you're the father or someone else who's affected by this. You cannot sue the abortion doctor. It's not saying that you can't sue the abortion doctor, but it's not saying that you can either. And in Texas, that kind of lawsuit would be called a wrongful death lawsuit. And unfortunately, the wrongful death statutes here in Texas actually create an exception that do not allow for suing for wrongful death for an unborn child in the event that death was caused by an abortion. So if this passes, that would still be the case, that you would still not be allowed to sue for the death of an unborn child. It would be a criminal act, but you could not sue for it. So you kind of hope that the Attorney General seeks a civil penalty, or you hope that the district attorney in that area seeks criminal charges against the abortionist. but you would not have the right as the father or someone related to the family or someone else who could be a party. You would not have a right to bring a cause of action if this bill passes as written. All right, let's keep going. Section 170A.007, creating a disciplinary action. This is in the Health and Safety Code. So this is creating a disciplinary action for members of the medical profession, for any kind of healthcare professional, physician, or other healthcare professional who performs, induces, or attempts an abortion. That's saying that they can have their license revoked if they do that. Okay, let's keep on going here. Section 3 of the bill says Section 2 of this bill, takes effect to the extent permitted on the 30th day after 1, 2, 3. So 1, 2, and then it says or 3. So if one of these three things happens, then this bill becomes effective. And what it's really saying is that until one of these three things happens, this bill is not effective. This bill just kind of sits there on our books, but it actually can't be enforced. It doesn't actually do anything until one of these three things happens. So what are the three things that could trigger this bill becoming effective? And that's what these kind of bills are called. They're called trigger bans, in that they ban abortion when they are triggered by some outside circumstance. So let's look at what those circumstances could be. So one circumstance is the issuance of a United States Supreme Court judgment overruling wholly or partly Roe v. Wade as modified by Planned Parenthood v. Casey, thereby allowing the states of the United States to prohibit abortion. We're going to come back to these. Number 2, the issuance of any other United States Supreme Court decision that recognizes wholly or partly the authority of the states to prohibit abortion. Or adoption of an amendment to the United States Constitution that wholly or partly restores to the states the authority to prohibit abortion. Okay, so this is in some way the most problematic part of the bill. There's already plenty of problems that we've already run across, but in some ways this is one of the most problematic. This is saying that this bill does not become effective until Roe v. Wade is overturned. That's criteria number 1. That's really what criteria number 2 is as well. And then number 3 says, or we get a U.S. constitutional amendment. So why is that a problem? So what that's really doing is legitimizing Roe v. Wade. So the Constitution, the supremacy clause of the Constitution says that this Constitution and the laws which shall be made in pursuance thereof shall be the supreme law of the land. Well, I think most Republicans, most pro-life people agree that there's no right to abortion in the U.S. Constitution. And there's no right for the courts to prevent states from outlawing abortion in the Constitution. And that's the reason that we all say, that's the reason that we say, well, I'm going to vote for a Republican president so they can appoint pro-life justices. And why? So they can overturn Roe versus Wade, right? That's one of the big reasons that a lot of Republicans vote for Republican presidents. It makes sense. Of course, that hasn't happened, and that's another story. You can go find that. We have a talk on our YouTube channel here called 48 years, or whatever the year is of the talk, 45 years sometimes, 45 years of failure, 45 years of false hope, abortion in the Supreme Court. You can go learn more about that. Anyways, we all agree that the Supreme Court should overturn Roe versus Wade. But what would be the legal basis for them to overturn Roe versus Wade? It would be that Roe versus Wade is unconstitutional. That's the only legal basis that they would have for overturning it. But if we agree that it's unconstitutional, that also means that it's not the supreme law of the land, right? It's not a law made pursuant to the Constitution, so it's not the supreme law of the land. Which begs the question, if it's not the supreme law of the land, then why are we acting like it is, right? If Roe versus Wade is unconstitutional, then it's not the law. Then why are we treating it like it's the law? And this bill just perpetuates that. This bill just really, ultimately, you know what this bill does? It codifies Roe versus Wade into Texas law. It says Roe versus Wade is the law of the land, and we are not going to ban abortion in the state until the Supreme Court overturns it itself, or we pass a U.S. constitutional amendment changing the law of the land. That's what this bill does. It codifies Roe versus Wade. You know what? Now President Joe Biden, one of the things that he and Kamala Harris, now Vice President Kamala Harris, ran on, they said that we're going to codify Roe versus Wade. Well, you know what? They don't have to, because we're already doing it in Texas. That's what this bill would do. It would codify and enshrine Roe versus Wade into Texas law and say we're not going to ban abortion until they overturn Roe versus Wade or we pass a constitutional amendment overturning Roe versus Wade. Wow. Okay. Well, again, like I said, this is really legitimizing Roe versus Wade, which is a big problem. We don't need to be doing this. And you know what? It's not just legitimizing Roe versus Wade. It's ultimately a declaration of surrender. What we're really saying is, dear Supreme Court, dear rest of the country, dear everyone, we will not ban abortion in this state until one of these three things happens. Until one or two, which would be the Supreme Court does it themselves, or the entire country passes a constitutional amendment that overturns Roe versus Wade. But we're declaring surrender on the issue of life. We're declaring surrender on banning abortion. We're declaring surrender on abolishing abortion and saying we will not abolish abortion in this state until the Supreme Court or the rest of the country gives us permission to do so. We're declaring surrender. And we don't need to do that because there's nothing in the Constitution that allows for a right to abortion. We don't need a constitutional amendment. We don't need that. There's no right to abortion in the Constitution. In fact, the Constitution says two things. It says that powers not delegated to the federal government are left to the states. Where have we delegated to the federal government a right to an abortion? Where have we delegated to the federal government a right to keep us from outlawing abortion? It's nowhere in there. Secondly, the 14th Amendment says that no state shall deny to any person within their jurisdiction the equal protection of the laws. But that's what we're doing. We're saying that we are going to continue to deny the equal protection of our laws until the Supreme Court tells us that we can follow the Constitution. Wait, do our leaders swear an oath to the Supreme Court? Or do they swear an oath to the Constitution? It sure sounds like from this bill that we're swearing an oath to the Supreme Court, when what we should really be doing is following the Constitution. All right, let's keep going. Here's one other thing that it says here. It says, Section 2 of this Act takes effect to the extent permitted. To the extent permitted. What does that even mean? Wait, are you saying that even if the Supreme Court does overturn Roe versus Wade, or even if we do have a U.S. constitutional amendment to overturn Roe versus Wade, that still there's something else out there that could prevent this bill from going into effect? Okay, wow. Talk about looking like you're doing something without really doing anything. Right? That's really what this bill does. It looks like you're doing something without really doing anything. And I'll talk more about that in just a minute. But again, here they're saying, not only do we have to wait for the U.S. Supreme Court decision, but there's even something else out there that could keep us from abolishing abortion in Texas. Even if the Supreme Court were to overturn Roe versus Wade, there's still something else that could stop us. Okay. All right, and that's basically the bill. It says that the bill is severable and then it takes effect September 1st, 2021. Of course, we know it doesn't actually take effect September 1st, 2021. It doesn't actually take effect until Supreme Court overturns Roe or we pass a U.S. constitutional amendment. So overall, let's just a few points about this overall. Overall, here's one of the best things we could even say about this bill is that it's a waste of time. That's one of the best things we could say. Because guess what? It's already the law in Texas that we have a ban on abortion with lower penalties and with immunity from others. That's already the law in Texas. That was the law before 1973 when the Supreme Court ruled in Roe versus Wade. That was the law we had on the books then. And guess what? It's never been repealed. We've continued that in our civil statutes ever since. So that's already the law. We already have a ban on abortion on the books that has a lower penalty and it has immunity for the mother. That's already the law on the books. So why are we doing this? Why are we doing this? Some people say, it's because we can't trust the pre-Roe laws. Well, the only reason that you could say that, they say, well, they're not enforceable. Yeah, but if the Supreme Court overturns Roe, they would be, right? Under that thinking, under the thinking, if you're already operating under the assumption that Roe versus Wade is constitutional and does stop Texas from abolishing abortion, then, okay, this bill doesn't become effective until Roe versus Wade is overturned anyway, which is this exactly when the pre-Roe laws would also become effective under that line of thinking. So why do we need this bill? Why do we need this bill? Would already be a ban on abortion, and it would already be homicide. In fact, it would be capital. It would be even stronger without this bill. Because if you take the pre-Roe laws against abortion, couple them with our homicide code here in Texas, it would be homicide for the abortionist to kill an unborn child. It would be a capital felony. But instead, we're actually lowering the penalties under this bill for an abortionist to commit an abortion in Texas than if we went under our current laws. So, if you really want to law, that's going to be effective, we need to pass the Abolition of Abortion in Texas Act, which provides equal protection and abolishes abortion now. But I'll come back to that. The other thing that this bill does, we already talked about, it denies equal protection by codifying into our statutes that mothers have a right to cause the death of their own children. It's codifying in our statutes that a mother, as long as she's unassisted, that a mother has a right to kill her unborn child. That's what this bill says. And that's what almost every pro-life bill says, except for the Abolition of Abortion in Texas Act. That's a bill of abolition. What does that do? By denying equal protection, you're preventing our justice system from considering each case on a case-by-case basis, which is all that equal protection means. All right, like we said, this bill legitimizes Roe versus Wade. And in my book, any bill that legitimizes Roe versus Wade is wrong. It's wrong, it's illegal, it's unconstitutional, it violates our oaths of office, which I, even as an attorney, have sworn. And not just that, it's evil. Legitimizing Roe versus Wade is evil. Imagine if President Biden said you could not own a gun. Right? Imagine if he said that. He issued an executive order that said you were prohibited from owning a gun. Would you turn around and say, well, until President Biden says otherwise, I guess I have to turn in my gun and I can't own any guns? Is that what you would say? Well, Bradley, the Constitution protects my right to own a gun. Just like it does. Yeah, it also protects the right to life. It also protects the right to life and the right to equal protection of the laws. And yet that's what we're doing here. Imagine if President Biden said, oh, you can't read your Bible. I mean, would we say, well, until he says otherwise, I guess I'm not going to read my Bible? Because that's what this bill says. This bill says until the Supreme Court says otherwise, or until we amend our Constitution, which is unnecessary, until we do that, then we have to allow prenatal homicide to continue in the state, prenatal genocide to continue in this state. That's what we're saying. Now imagine President Biden telling our civil leaders who have a duty under the U.S. Constitution, Texas Constitution, and before God to provide equal protection to people and to provide justice to victims of murder. Imagine President Biden telling them they can't do that. Right? We would say, Republicans would say, well, who died and made him God? Well, the same is true not just for the president, whether it be Biden or anybody else. It's also true for the Supreme Court. Who died and made them God? Who died and gave them the power to amend the Constitution at will? Who died and gave them the power to order states to allow prenatal homicide within our jurisdiction? No, absolutely not. Finally, this, as we already said, this bill is a declaration of surrender. It's saying we promise not to ban abortion in Texas until you give us permission, Supreme Court, or until all the states get together and amend the Constitution. That's what this bill says. Wow. So what should you support instead of this bill? Well, what I'm going to be supporting, and what I hope others are as well, is the Abolition of Abortion in Texas Act. Roe versus Wade is not the law of the land, and we need to stop treating it like it is. We need to start providing equal protection. We need to allow people to sue abortionists. The Abolition of Abortion in Texas Act is going to be carried by State Representative Brian Slayton, does all of that. And you know what? Politicians are always going to do as little as we let them get away with. And so we need to support the Abolition of Abortion in Texas Act. instead of letting politicians get away with bills like this one that look like they're doing something when they're not really doing anything, or what they are doing is actually bad and making the problem worse. This bill will not overturn Roe. It will not save any babies. It will only make the problem worse. It will only make the law worse, and it will further reinforce Roe versus Wade. And so that's why I give a thumbs down to SB 9, also SB 391, and House Bill 1280, which are being called the Human Life Protection Act. So please join me in opposing these bills that deny equal protection and ultimately just perpetuate the problem and allow abortion to continue in our state. We need to support abolition now. Thank you.